The where yeah where no action, nothing. Where we landed was this, and I was really grateful to get to tell a story, to see people like the characters like Blade with Wesley Snipes, who's a guy that should have a third act. That feeling and that gasp that comes out of people when he crosses the frame in the movie is just like, I don't know, it's a feeling that I just want more of, and I think I'd be able to do that as a supporting actor. I'm writing a little something right now that is as an ensemble, but it's I like that he's isolated. If Deadpool becomes an Avenger or an X-Men, we're at the end. That's his wish fulfillment, and you can't give him that.
Hi, friends. It's Katie from Without a Crystal Ball. Welcome back to my channel. Blake Lively and Ryan Reynolds want you to believe that they are still top dog A-listers and that their lives are fantastic and magical, but yet they're suing, or at least Blake is suing, for severe emotional distress. And she is so traumatized by what she went through for the past 2 years, while still maintaining that people like me who have a mouth and a brain and critical thinking are part of an orchestrated smear campaign. And I'm not a bot, I'm a real person. But Blake Lively has been spending months trying to tell us that her best friend Taylor Swift is on her side and that even though they haven't been seen together, Taylor forgives her. And then on Monday, Travis Kelce unfollowed Blake and Ryan on Instagram. And then Blake followed back by unfollowing him. Ryan is still apparently following Travis. Now, there's a lot of speculation about what's going on, what's happening, and if there's sources that are talking to the Daily Mail and they're saying that it's because they Travis thinks they're fake and he's not down with people that are fake and he doesn't want to get dragged into it and his girlfriend doesn't want to get dragged into it and they don't want to be around people that are using them and they are distancing themselves because they don't know that they can trust them. And, I have this weird thing about life. When you get to the level of fame that these people have, they see who the people they are when they're with them. They know who they are. So it's just wild to me that they are now distancing themselves. They were good friends as long as it was beneficial for each other, but they're not friends now when it's not beneficial. So while the dragons are falling, there's this lack of authenticity from my perspective because I don't know how you could have been around Blake and Ryan for a decade and not see them for who they were. You know what I mean? A lot of relationships in Hollywood are all about opportunistic and opportunities and clout. And I don't think the Reynolds have a lot of friends that are like true friends. But needless to say, Travis Kelsey, and Miss Taylor Swift don't want to be involved in this. They have sent a message that they are unfollowing. They are distancing themselves from Blake and Ryan, and things will never be the same. There will never be Blake and Taylor being besties ever again because, well, quite honestly, I don't know how you forgive someone for calling you a dragon. That's just really, that's being very, you're using someone. But what bothers me about the message that's being sent by Taylor Swift's PR that she doesn't want to be involved, it's like someone who has a lot of power, like Taylor, who's was worth 1 billion. She just fell off the billionaires list. But someone who has a lot of power and an influence trying to say, like, I don't want to be involved in this because I'm powerful and influential, and I don't want people harming my reputation because I got to think about my brand. And that's just not how the court of law works. Okay. So you can tell someone all day long that you don't want to be involved in something. But if you're involved and you were there at conversations that happen and you have relevant information, you will be a witness. You will be asked to provide documents. You will be asked to provide communications. If you have text messages, say it's like subpoenas, they can literally demand that Taylor Swift hand over all of her communication, all of her text messages, all of her emails that pertain to her conversations with Blake Lively as it comes to It Ends With Us. I understand that Travis and Taylor want to distance themselves, but just saying that you want to distance themselves doesn't mean they're not going to be involved. Okay. That's just PR. They don't wanna be affiliated with this drama that's happening in the criticism and in the coverage, but they're still going to be involved in the case. Taylor's music was used. Blake leveraged Taylor's music as a weapon in the case, in according to Baldoni, and threatened to pull her music if people didn't comply. Taylor was at conversations involving rewriting of scenes that Baldoni says he felt pressured and like bullied into compliance, and that she was using Taylor and Ryan to get and flex her power. And for Taylor to try to, in many ways, claim that she wasn't really involved is asinine. Asinine, absolutely asinine, because her music is in this film. A composer that she works with is the composer that took over the music for this film. An editor that edited one of her music videos edited this movie. Taylor's hands are involved in this. Whether or not she wants that or not, they are. And whether she thinks she's been misled or not, Taylor's been in the industry for years. And I don't believe when someone says they were just being used by a friend. Taylor didn't get to the level that she is because she's a good singer, because she's not a good singer. There's a lot of singers that have much better range, that have higher octaves, that are technically a better singer than her. She can write good stories. She's a good storyteller, and her music is all about writing stories, right? And maybe that's where people find her relatable, right? But Taylor has also used her music to pick fights with people that she's mad at. I mean, she spent years in a fight with Katy Perry about backup dancers. So I don't believe Taylor isn't involved. I believe she's involved as much as her music's in the film. She was involved in conversations and she has relevant information to share. And guess what? If she gets a subpoena, it doesn't matter whether or not she wants to be involved. She has to comply. And thus far, I want to note, we haven't received any motions to quash from any of these third parties that are people that would have received requests for information. And it's April 30th. The only people that are currently fighting to comply with discovery are Marvel. So we haven't seen Gigi or Bradley. I don't know if they're going to get subpoenaed, or Hugh or Taylor. None of those parties have filed motions to quash, meaning they likely are producing information and complying with court orders. So they can say all the time, like they don't want to be involved, but they're going to be involved, regardless if they want to or not. So, I mean, that form and change how she views her friendships? Sure. But you can't tell me that Taylor didn't know who Blake was, or Ryan for that matter. They might be good at love bombing, but the amount of time they spent together, I just don't buy it. But when it comes to involvement in films, we know that Ryan used a character in the movie Deadpool and developed him in order to, what Baldoni says is, bully him and use this as a method to defame him. And Marvel wants out, and they say that it's not defamation, and Ryan's case is likely to be dismissed. And so please pause it on pending the motion to dismiss, or just please quash the subpoena entirely. And Wayfarer filed a letter to the judge response, which I want to talk with you about right now. Baldoni's team and Brian Friedman and the attorneys are basically saying that Marvel did not meet and confer with them in good faith to resolve the issue. They said they took a call with them on April 2nd. They were sent a letter containing objections to the subpoena, which were the same ones set forth in the recent letter motion. And then on April 7th, this says my office met and conferred with Marvel's counsel via telephone about the objections. And although we attempted in good faith to address their purported concerns about confidentiality and relevancy, they interrupted us, refusing to engage in the discussion. Instead, they interjected and stated he merely wanted to know what documents the Wayfair parties really needed, regardless of the subpoena's demand for all documents, concerning the creation, development, modification, portrayal of Ryan Reynolds' nice fool character from Deadpool and Wolverine, and Justin Baldoni. And they said, for sake of clarity, Nice Pool is a defamatory and mocking portrayal of Baldoni, as alleged in the Wayfair party's pleading, and is used in the film Deadpool and Wolverine to mock events that allegedly took place between Baldoni and Lively on the set of the film It Ends With Us, those same events that are subject of this lawsuit. We responded that we wanted Marvel to search for and produce documents concerning Reynolds, a writer and the star of the film's participation in the development of Nice Pool and the communications related to Baldoni, including the character's portrayal of Baldoni. Marvel counsel agreed to discuss a limited subset of requested documents, and then the telephone call ended. However, the next communication they got was an email stating that Marvel would be moving to quash the subpoena. And then it's a subsequent letter motion. And as far as they know, Marvel never searched for the narrowed scope of documents or even ascertained whether there was a handful of documents easily accessible to Marvel that can satisfy the subpoena. They said that it should be denied because its failure meaningfully meet and confer prior to seeking a judicial intervention. And they said even worse, their motion neglects to advise the court of Wayfair's proposal to narrow the scope of the subpoena. Instead, inaccurately represent to the court that they're seeking all documents about a character in a major film and all documents concerning an actor. So they go through the rules that say that you're allowed to do discovery. And as long as items are relevant to a case, they're allowed to seek discovery, as long as the burden and the expense isn't outweighed by the request. And they said that Marvel is contending that the documents are irrelevant because, according to Marvel, the character is purportedly an expression of opinion and not one of fact. And they said to begin with, whether Nice Pool is an expression of opinion or not, while perhaps relevant on a motion for summary judgment, is entirely irrelevant to determining the propriety of the Wayfair party subpoena. Indeed, even if the Nice Pool character were found to be an expression of pure opinion and therefore inactionable in its own right, information concerning Nice Pool and communications exchanged in relation thereto would still clearly be relevant to, among other things, the question of Reynolds' alleged malice. They're saying that the communications that Reynolds had, even if Nice Pool is deemed like an opinion and it's, satire, that the conversations are relevant because it can actually show his mindset and his alleged malice. It says that is especially true given that on a big budget superhero movie, Reynolds insisted on the ill-fitting and belated addition of Nice Pool to the script during the period at issue during this litigation, and in fact, credit it in the film It Ends With Us. Importantly, the information sought could establish malice not only in connection with this portrayal, but also in connection with other defamatory statements Reynolds made at or about the same time over the same events that caused the Wayfair party substantial harm. And they say that their argument does not apply to the request for information concerning Baldoni. And even if they were to consider this position, they argue that a statement of opinion is actionable if implicitly based on undisclosed facts. The court applies totality of circumstances, blah, blah, blah. Indeed, the case that Marvel cites for the unsupported proposition that Nice Pool is clearly a joke and not grounded in any factual basis was decided that after limited discovery on the issues raised in the motion for summary judgment. So they're using a case that allowed them to get discovery, and they were only able to make that determination after discovery happened. They also argue that Wayfair has less than burdensome means through which they can obtain relevant documents. Marvel does not explain how a subpoena is unduly burdensome, especially given the Wayfair party's agreement to narrow the scope. They don't claim it will incur significant expense to locate or produce the documents, and compliance with the subpoena may moot the need for further discovery concerning Nice Pool. Third, the suggestion that by Marvel that the Wayfair party should obtain documents and information concerning Nice Pool from other parties is insincere because Marvel also seeks a protective order prohibiting the disclosure of Marvel's confidential documents by any party or other non-party in the action. Marvel does not merely seek the relief in the alternative to quashing the subpoena. Thus, Marvel simultaneously contends that they should seek them from the parties here too, but then also not permit any of those parties to disclose their documents. They keep saying that the documents are sensitive because they relate to the development of a character in an ongoing movie franchise, yet as Marvel itself recognizes, this court has entered a protective order that provides for ample protection of any proprietary information. Marvel notes that whether and how unspecified storyline plots and characters will appear in upcoming unreleased project is the subject of much interest. Information is closely guarded by Marvel. However, the subpoena only seeks documents concerning Nicepool and only Nicepool in one movie, Deadpool and Wolverine. And the character does not appear in any other film in their franchise and will not appear in any other future films since it was killed in its first appearance. Importantly, the case cited by Marvel purported to establish that movie scripts constitute confidential information involved scripts for unreleased films. I do think they're going to have a problem with that because when I was reading their argument to the court, I was like, but Nicepool's dead, right? How are you going to bring him back? Is it going to be like the origins of Nicepool? He wasn't that big of a character in the film, from my understanding. They also brought up the stuff about the motion to dismiss, but then they mentioned that Reynolds has neither sought nor obtained a stay of discovery in connection with this dismissal. And as detailed in the Wayfarer's party's opposition to Reynolds' motion to dismiss, there is not substantial grounds for dismissal of the claims against him. And the unlikely event claims against Reynolds are dismissed with prejudice. The information sought in the subpoenas remains relevant to the suit against Lively, as the Wayfarer parties contend Reynolds was acting as an agent of Lively. They say they have worked in good faith and have tried to avoid undue burden upon Marvel to narrow the subpoena about his participation in the development of Nicepool, and they will not be prejudiced if the court declines to stay compliance with the subpoena because the film has already been released. And any non-public documents can be marked confidential pursuant to the protective order. It did kind of seem like a flex, like Marvel was trying to say, like, we don't want to give up our copyrighted information, but yet I think what Marvel is trying to hide is they don't want the public to see that a character in a film may have been based upon somebody that Ryan has a beef with. And what if some of the things that Ryan told writers or they talked about doing a Nicepool or conversations about Baldoni were a part of that conversation? How does that look to Marvel and Disney, particularly, that's supposed to be marketed to children, that the people that are involved in making their films are using their films as a platform to bully and intimidate others? It's ugly, actually. And I think that's why they don't want that out. That's what I think. I don't think it has anything to do with intellectual property. I think they don't want to tarnish their brand that that would cause parents to be like, well, I don't want my kids watching those films. And I know Deadpools are R-rated movies, but still, I think it's a good response. I don't think they'll get the motion quashed because discovery is for this purpose. And if they're only looking for pretty limited information, I don't think he's going to deny it because how do they just have to go on the nudge of trust me, bro? Trust me, bro. We all know that trust me, bro, when it comes to Ryan Reynolds doesn't work because he's a liar. Jen Abel also filed another amended complaint about Stephanie Jones, and I don't know anything about indemnification or contribution, which are the claims that she's bringing from Stephanie. But the main gist of the article of the amended complaint is that Jen was working for Stephanie when Stephanie and Jones work when she was doing the PR for Wayfair, and she was working as an employee of Jonesworks, being paid by Jonesworks, and she was managing a Jonesworks client. And she argued that even though Stephanie keeps saying that she wasn't involved in this, there's emails that she sent, which are to Jamie Heath talking about how involved she has been with the situation from the beginning and how she can offer the same services and she has options for them that she can give in terms of like the crisis PR. Jen's motion is really trying to establish that even though Stephanie's trying to pretend like she wasn't involved in whatever this is, she was involved. And she's not being sued, which Jen's amended complaint points out. And they added a part of this amended complaint that I think is interesting because a lot of what she's in this amended complaint was already in the previous one about the indemnification, about the contract not being allowed, how she should be allowed to use California law. But she brings in quotes from emails that Stephanie said. And she says the conduct alleged by plaintiff to have been committed by Abel and to have caused harm to plaintiff consists of public relations activities on behalf of the Wayfarer and Baldoni during the time period when they were clients of Jonesworks. To the extent any such conduct by Abel was undertaken as alleged, which Abel disputes, it was undertaken in obedience to Jones Works' directions. For example, the plaintiff alleges Heath and Baldoni, in their own capacities as representatives of Wayfair, were directly engaged via contract with Jones Works, which engagement gave rise to the retaliation campaign at issue. Miss Abel worked as an employee of Jones Works, which position directly gave to the retaliation campaign at issue. So they're using Blake's own first amended complaint to show the court, like, Blake even says that I was a employee of Jones Works and Baldoni was being repped by Jones Works. And she says that Abel disputes the claims that the plaintiff makes, but she says that it appears that the substance of her allegations are that she coordinated an astroturfing campaign to discredit and bury plaintiff. And she quotes Blake's First Amendment complaint that she solicited, developed, and implemented and promoted a covert multi-tier press and digital plan to harm plaintiff and discourage her from making public statements harmful to Wayfair and Baldoni, among others. Abel publicly disclosed information concerning plaintiff's marketing decisions, moral character, private life, and family, which showed plaintiff in a false light. And Abel conspired with others to commit those acts. So she's taking and pulling directly from Blake's complaint and saying, this is what Blake says I did, trying to show that she was doing this for Jones Works. And it says plaintiff allegations against Abel are of conduct and communications directed at the press and the public to garner good publicity and to eliminate or minimize bad publicity for her clients or for the clients Wayfair and Baldoni, which were the very essence of what is public relations professions. And she says Jones and Jones Work gave Abel directions to carry out the duties of a competent public relations professional on behalf of the clients, Wayfair, Heath, and Baldoni, including but not limited to garnering good publicity and eliminating or minimizing bad publicity for them. In addition, Jones personally interfered with Abel's competent handling of her duties, including by attempting to insert herself with poorly timed negative communications to the press and public that were discovered by plaintiff's own publicist, Leslie Sloan. Jones' blunders clumsily disrupted a putative truce with Sloan by communicating negatively with the media about the plaintiff, exacerbating negative press and public attention on plaintiff by adding fuel to negative stories of a feud with plaintiff. Jones' incompetent handling of communications with the press only caused negative stories to circulate further and attract greater attention. So that's the crux of the case that Wayfair has with when it comes to Jones, is that she was the one that actually leaked a story and spoke to the Daily Mail and responded to claims, and then that exacerbated the feud and got Leslie Sloan even more mad, and then it just escalated from there. And what's really weird is that I don't really understand how any of this is defamatory. You know what I mean? Like, even if somebody speaks about you publicly, like a smear campaign is actually putting out false information about someone. And if it's not false that you had a fight about what happened on set with like how the direction of the creative directions of the film, that's not a lie, right? If that actually happened. So it's not defamatory. The best defense for defamation is the truth. But apparently, Blake views just talking about her not in a positive light as defamation. That's like basically what I've gathered from this entire case. Because I've yet to find anything that was put out that paints her unfavorably, other than, they had fights about the creative direction. And then the fact that her company is named as the company that led the smear campaign, it's very weird that she's not a defendant. And I've said this all along. She said Abel was named as a defendant in plaintiff's pleading only because of and in direct consequence of Abel's discharge of her duties as a competent public relations professional employed by Jones Works. Abel was named as a defendant in plaintiff's pleadings only because of and in direct consequence of Abel's obedience to the directions of Jones Works. Upon information and beliefs, Jones Works was not named as a defendant in plaintiff's lawsuit because Jones and Jones Works conspired with plaintiff to exploit Abel's private communications that Jones and Jones Works stole and unlawfully intercepted for the purpose of harming Jones Works' former clients, Wayfair, Heath, and Baldoni. That's them bringing in the subpoena. So they're introducing that into the case. And I do think it's This is a strategic move, my opinion. A lot of lawyering and having gone through lawsuits is really working like, if you're the client, it's working with your attorney to figure out what you can use as leverage in a case to either apply pressure to people involved that will either get them to flip and, like, wanna settle or dismiss their claims, or get them to realize that if they go this route, this is what your end result will be. Like you brought this up, you got them hyped up, but you forget that your business is the one that started this. I was working for you when this happened. You were engaged in the emails. You were communicating with us about this. You called it a nothing burger. You admitted to contacting the Daily Mail and then lied and said that you didn't contact them. The stories were put out there somehow. Whether or not they were actually defamatory is a whole nother thing. And that's, I think, what Abel is saying here is that everything she's saying that is wrong that I did is a lie. And I believe that too. But I think what they're strategically trying to do here is to put it on like, okay, you two that you conspired to bring it here. Don't forget that it was Jones's company that I was working with. And the only reason I was working with Baldoni is because I got that client from Jones Works and I was working for her company and paid by her company. And Jones can't say that Abel wasn't managing this client for Jones Works because she literally had other point people that were working on this too that were part of these teams that are not being sued. It's weird because there's other members of TAG and other members of Jones Works that were part of this quote unquote smear campaign that are not being sued. The only reason Abel is being targeted is because she's literally the enemy of Stephanie Jones and it's her text messages that they have. And so she has to be a party or else they'd have no reason to have these in this lawsuit. And I think it's very weird that if she has all of the stuff that's in Jen Abel's phone, how does she not have Jen's communications with Stephanie? Or did Stephanie leave those out? And why didn't Blake subpoena Stephanie for her communications, her emails, and her information about what she did? Did she not want any sort of verification of what Stephanie did, or did she not care? She was only after the dirt, because that's kind of what it feels like. If you're not going to get what Stephanie's business was doing, because she was the public relations person and you're not holding them accountable, you're holding her employee accountable, it's asinine. And I think part of this is basically saying to Stephanie, like, you guys did this. You illegally brought this stuff to this court with that fake subpoena. And if anyone's going to be held liable here, it's you. It wasn't me. You're the one that actually went to the press, not me. You're the one that got this exacerbated, not me. I didn't talk to the press, you did. And if it works, it works. But it also might pressure Stephanie to turn on Blake or to settle. That's kind of how I view it. But it's not good for Blake. And it doesn't make sense in this case. And Stephanie can argue all day long that she wasn't, working under the obedience of Jones Works, but it's a lie because Stephanie was emailing Baldoni, the day she fired Abel, reminding them that they have a contract and they're still under contract and they're still her client. So is she working for Jones Works then if it's your client stuff? And even though they left and went to Jen, it feels like it's a fight because she's mad that she got her client left. And now she's just trying to smear her client, get back at her former employee, and destroy her former employee's business, which is disgusting. So Blake's dragons are falling. They want out, but they're not going to get out. Marvel is not likely to get quashed. At least I don't think so, at least for the purpose of discovery. And Jen Abel is saying to Stephanie, put up or shut up. And if you want to bring this to the court, we're going to let you pay for it. And then that'll make them think again about doing this next time. I don't know if the laws of California will be able to override the New York stuff and the contract stuff. That's the stuff I don't know. But if it works, it's a good strategic tactic to put pressure on them. So what are your thoughts about this? I think this, in my opinion, is going to make things a lot worse for Blake and Stephanie. And I think this bravado they have in the press acting like they're in first place is not true because if they were in first place, they would have the evidence in court and they don't. So do you think it'll work? Tell me in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed and click the bell so you never miss a video. Thanks so much for watching. Bye guys.